Hey boys and girls, today we're going to talk about fiduciaries. Now, what is a fiduciary? Well, a fiduciary is someone who has undertaken to act for and on behalf of another person in a particular matter in circumstances that give rise to a relationship of trust and confidence. The fiduciary accepts legal responsibilities for duties of care, loyalty, good faith, confidentiality, and more when serving the best interests of the beneficiary. Strict care must be taken to ensure that no conflict of interest arises to jeopardize such interests. Examples of fiduciaries would include trustees, who are fiduciaries to beneficiaries, directors, who are fiduciaries to a company, agents, who are fiduciaries to a principal. And in this context, when I talk about agents, I'm not referring to like real estate agents. Agent in the legal sense refers to a representative who acts on behalf of another person. Such agents would hold fiduciaries to the person on whose behalf he acts for. Well, another example of fiduciaries are lawyers like myself. I owe fiduciary duties to my clients. Other examples of fiduciaries would include high-ranking employees of companies, for example, the chief executive officer or the chief financial officers, who are also considered fiduciaries to the employer company. Fiduciary duties refer to the duties that a fiduciary has towards the beneficiary on whose behalf the fiduciary acts. Now I'm going to discuss some of these duties that fiduciaries owe to the beneficiaries. Number one, fiduciaries owe their beneficiaries a duty of care. This includes the responsibility to inform himself. The fiduciary has to inform himself as completely as possible in order to exercise sound judgments that protects and beneficiaries' interests. This can involve the thoughtful consideration of options and sensible decision making that's based on a careful examination of available information. Number two, the duty of loyalty. Fiduciaries owe their beneficiaries a duty of loyalty. This would include acting in the best interests of the beneficiary at all times. In fact, the fiduciary has to put their well-being first and foremost, and includes the duty of the fiduciary to excuse himself from taking actions when there's a conflict of interest with the beneficiary's welfare. Therefore, in the case of lawyers, they clearly cannot act for two different clients with conflicting interests, because then they are not able to act in the best interest of, you can't possibly act in the best interest of two people with conflicting interests. Number three is the duty of good faith. This duty pertains to always acting within the law to advance the interests of the beneficiary. At no time should the fiduciary take actions that are outside of legal constraints. Number four, the duty of confidentiality. A fiduciary must maintain the confidentiality of all information relating to the beneficiary. They must not make use of any form of it, whether written or spoken, for their personal gain. So lawyers, company directors, trustees under a will have to maintain strict confidentiality and cannot leak the information for others to use or to use the information for themselves. Number five, the duty of prudence. Fiduciaries must administer matters and make decisions concerning the interests of beneficiaries with the highest degree of professional skill, caution, and critical awareness of risk. In fact, if you read the Trustees Act, Part 2 of the Trustees Act imposes certain criteria on investments that trustees make when managing the funds that the trustees have dominion over. Number 6, the duty to disclose. Fiduciaries must engage in completely truthful behavior, disclosing any and all relevant information that could have an impact on their ability to carry out their duties as fiduciaries or on the well-being of the beneficiaries' interests. Therefore, a breach of fiduciary duty occurs when a fiduciary fails to act responsibly in the best interest of the beneficiary. However, the beneficiary may waive the duty by consenting to actions that would otherwise be in breach of the fiduciary's duty. For example, a director who is a fiduciary to the company is not allowed to usurp or take over business opportunities that were intended for the company. However, if the company consents to the director taking over the business opportunity, then there will be no breach of fiduciary duties. Number 7, a fiduciary cannot profit from his position as a fiduciary unless the beneficiary consents. For example, the example that I just talked about, where the company approves of the director taking over a business opportunity for himself. Also, a fiduciary cannot accept commissions or other unauthorized payments from third parties for services or other benefits provided when these are connected to the relationship between the fiduciary and the beneficiary. So, if a company director takes secret commissions or bribes from a supplier, from a customer, then he would be breaching his fiduciary obligations to the company. What happens when the fiduciary duty is breached? Well, the beneficiary can sue the fiduciary for a breach of fiduciary duties. So when filing a lawsuit against the fiduciary, the beneficiary must prove that the fiduciary duty existed, okay? So if a company is going to sue the company director for breach of the fiduciary duty, for example, taking a secret commission, the company must first prove that a fiduciary duty exists, and this is very easy for company directors because it is established law. Number 2, the company, the company, the beneficiary, has to prove that the duty was breached and that this breach caused loss to the principal. The principal would be the company. Typically, the principal will then claim damages for the breach in the form of money for lost profits, lost income, or take back the property. In addition, there are several other remedies for a beneficiary, including a rescission of a contract. Rescission means cancelling a contract if the contract was entered to in breach of fiduciary's fiduciary duties. Another remedy would be equitable compensation payable by the fiduciary to the beneficiary. Equitable compensation essentially means paying money, something like similar to damages. Alternatively, another remedy would be an account of profits payable by the fiduciary to the beneficiary. So therefore, if a company director, usurps or secretly takes over a business opportunity, the company, when suing the company director, has the remedy for account of profits. The director has to account for the profits he made from taking over the business opportunity. He has to account for it to the company. Another remedy will include transferring title of property from the fiduciary to the beneficiary that was wrongfully transferred in breach of trust. Another remedy for breach of fiduciaries would include injunctions to prevent the fiduciary from committing a breach or further breaches.